Hello all, Don Rolfe here with Northwest Legal Planning, back after the holiday weekend. I hope you all had a wonderful Thanksgiving this past Thursday and survived Black Friday and what is today, December 2nd, Cyber Monday. I must have received at least 4 times the amount or 5 times the amount of email today, both personally and business, telling me about all of the cyber deals that I could get today. And I'm not on here today to offer you a Cyber Monday deal, just to offer you some information about estate planning and the 4 facts or scenarios which will most likely lead me to recommend that someone get a trust-based estate plan rather than a will-based estate plan. The number one thing that will lead me there is if people are concerned about avoiding probate. If you're concerned about probate, you've been through a probate for family or friends or something like that, loved ones passed away, and you've been through the probate process, you know that it can be long, drawn out, a lot of forms to fill out, interaction with the court, fees to the court, perhaps more attorney's fees than you wanted to spend. And to avoid that, we can set up a trust, properly fund it, and then a probate won't be necessary. The second fact scenario that would lead me to recommend a trust over a will is in the event that there is ownership of real property, land, in more than one state. And the reason that we would want to have a trust in that scenario is that under a will, we would have to open a probate where you were domiciled, your home state, say Oregon, and then if you had real property in Idaho and Montana and New York, then we would have to open what are called ancillary probates. Basically, it's just a mini probate for that one or that real property that's in that state in each of those other states where you own real property. So we not only have your main probate, but then we've got probates for as many states as there are real property that you owned. So that is a scenario where it's just not only are we dealing with probate, then perhaps we're dealing with multiple probates. So we're going to want to stay out of that arena. Another scenario is when we have people who are wanting to maximize and simplify tax planning for estate tax purposes. And we can do this through a will-based plan. It's just oftentimes much easier to do it and a more flexible ways to do it through a trust-based plan. So if you have an estate that is taxable either federally, which if you do, that's quite a sizable estate, or taxable at the state level, which here in Oregon we have a very low threshold for taxable estates, and that's $1 million. If you own a house and you know have accumulated some assets over your lifetime, you're probably approaching that $1 million mark. So it's very easy to not realize it, but then get to the taxable level for the state of Oregon. And by doing a trust-based estate plan, we can have a little bit more flexibility in the way that we're going to treat estate taxes, what assets will count towards estate taxes, and how we'll handle that, and whether or not we can maybe move some stuff around after you've passed away. All legally, of course, within the law, just taking full advantage of what the law allows. And then the last is if you are, or if the client is particularly or any way concerned with incapacity planning and making sure that there's going to be some way for someone to step in and make choices for them and to take care of their day-to-day bills and payments and all of those things, to make sure that there's someone that's going to be able to step in and take care of those. If we do a will-based plan, we're going to rely upon a durable power of attorney for all of those things to happen. If we do a trust-based plan, we're going to have a successor trustee during incapacity that, as long as the trust is properly funded, will be able to step in as successor trustee and manage all of those things. Now, in the event that you don't have a will or a trust, you're looking at having a conservator and guardian appointed in the event that you become incapacitated. So doing a trust or will-based plan is better than not doing anything at all, especially if doing that will-based plan, you do have a very strong durable power of attorney that's been submitted to all of your financial institutions to make sure that they know who your agent is going to be. Hey, again, I am Don Rolfe with Northwest Legal Planning. estate planning and probate law firm located in West Linn, Oregon. If you have any questions about estate planning, probate, any of those things, please do feel free to reach out to me. You can go to myestateplanmeeting.com and get yourself right on my calendar for a complimentary half-hour estate planning strategy session. And again, go to myestateplanmeeting.com. If you like this, please hit the like button, thumbs up, whatever it is on the platform that you're watching. Leave a review on iTunes if you're listening to this as a podcast, or the other podcasting platform where you are receiving this. If you know somebody who you think may find this information useful, please share it with them or share it with the public in general. I just want to get this information out to people, and I hope that you are finding it useful. Until next time, take care. Goodbye.